plane from Chile, Santiago, and her plane had an emergency landing, so she won't be able to join us. But we're very excited to have this.
And she's fine.
She's fine.
Well, yeah, and she's fine. Doesn't no. But we're very happy to have our two panelists here that are super knowledgeable and are prepared to talk about tax issues. So I'm going to start with Adriana to introduce her. She is the partner in charge for KPMG's International Executive Services Group, which is expatriation and moving from country to country. She's also the head of the Argentinian part. She's a partner in charge, and she's got years and years of experience in comprehensive expatriate policies for international companies, analyzing the tax and social security implications derived from the transfers of employees to other countries. She is very well versed in migration, international assignment structuring, labor tax, as well as double taxation and other areas of taxation that are very complex. So she's a frequent speaker on these topics. She's an author and is well recognized in this field. So, and she's actually also been on the academic side as a professor for the Council of Economic Sciences and a contributing writer on issues of tax for Argentina and for Latin America. So, she graduated. She's a CPA, obviously. So I'll leave it at that. I do want to point out that there are bios of the panelists in here. And actually, we didn't really walk through the event because we sort of got started very fast. But just so you know, there's an overview of each of the panelists. There's a page to take notes. There's a list of all the people who are in attendance and the agendas here. So not to derail, because of course we have Juan Carlos, who likes to be known as Carlos Varela, and he is the managing office shareholder for Littler in Venezuela. And he splits his time between here and Venezuela, and very smart. He bought all his plane tickets in advance, which I guess is something that everybody does, but I think is a really good idea. He is licensed to practice law in Caracas, and his expertise is labor and employment law, executive and worker compensation, employment taxes, labor litigation, alternative dispute, labor arbitration, and audits. He's also the co-chair of the company's Latin American practice, and he's on the firm's board of directors as well as part of their employee practice group. So, and he's also in his spare time a professor at the Universidad Católico Andrés Bello. And again, as almost every single one of our panelists has so far, he's written and co-authors articles of interest on his practice. So, and he's very well recognized with numerous awards in Venezuela and in Latin America. He earned a JD, his Juris Doctorate from Venezuela's Universidad Católica Andrés. He also earned an LLM from the University of Illinois, for you Chicagoans here, and another LLM from the University of Miami in 2011. So welcome, Juan Carlos and Adriana, and now I'd like to turn it over to Ken.
Great. So again, the deal here is the same as last time. I'll with a question or two, but the idea is to quickly jump in as you have your questions, comments, thoughts, or so forth. So the first question I had for this particular panel was, what is the hardest mistake to make, to fix once made? Once you've made a mistake, what's the hardest one to fix?
Okay. I don't like to use the word mistake, but I would like to say that I think that companies should understand that perhaps living in a global world does not mean that every country is similar in terms of taxation, income tax, and also social security. In fact, they are quite different. So I think that the main issue here is to understand that plannings became essential at the time of reducing tax and social security costs.
Carlos, have you had an experience at some point when a client calls you or a new client calls you and they explain what it is and you kind of just go, wow, without saying it like that, but I'm sure you have
Sometimes.
Yeah.
Sometimes. Well, the main issue and the worst mistake that is always happens is lack of planning. Lack of planning is #1 issue in the program. The reason why is that is Because in Latin America, you just got just one chance. If you don't do it right at the beginning, there's no way to fix it. And in trying to fix it, you make it worse. So basically, I think that the main issue the companies have to realize is get up, take a little time, a couple of minutes, 1 hour, 1 day, 1 month, plan, and then go and hire people, terminate people, settle.
Quick question on compensation costs then. Across some of the top countries in the region, can you run through some of those compensation costs and how they differ from country to country?
Yeah, yes.
I think most of you are in Brazil, and certainly some of you are in Mexico, Argentina, Colombia, Venezuela are probably the countries you see the most in this room, I would imagine. So maybe you can run through some of those countries.
Okay, I will start letting you know costs regarding social security, and then I would like to move on income tax. I think that social security is the area where we need to work hard in order to reduce costs. Because in our experience, what we have seen is that we have scenarios where double taxation is what happened in most of the assignments. Specifically in Latin America, you need to know that, for example, Brazil is the most expensive country in terms of social security. It reaches almost 30%. Argentina follows Brazil, where our tax rate is 23 or 27, depending on the activity of the company. You have Paraguay is 17th, Peru is 9, and in these cases, Social Security has no cap. That means that the global compensation in cash, in kind, incentives will be subject to Social Security. That is why it's so important. You know that in the Latin American region, perhaps there are totalizations agreements, but there are not so many totalizations such as in other regions, just as Europe, for example. And let me show you one example, because in terms of planning, what we have seen is that most of the companies use the policies that were prepared in the headquarters, where the headquarters were, for example, in Europe or perhaps in the United States. If you see the policies, you will find out that most of them says that the individual will remain in the home country payroll in order not to break coverage, social security coverage, and then they are seconded to another country where such country will pay allowances. What we have seen, and I would like to spend, for example, giving you an example, and I would like to use the Argentine case. If you have an Argentine individual going from Argentina to Colombia, for example, in Argentina, I have previously mentioned that the tax rate is 27 or 23%, and if the individual remain in an Argentine payroll, Social Security must be paid. It doesn't matter that perhaps the labor relationship will be in Colombia. In Colombia, the Social Security rate is 30% with a cap. The cap is to $7,500 the compensation. What it happens is that if we follow the policy, the individual will be paying Social Security in Argentina and also in Colombia. We have no totalization agreement between the countries. So there is no way to avoid the double taxation issue in this case. How companies solve these problems? Well, in this specific case, you have two different alternatives during the assignment. You can keep the individual under an unpaid leave, so the full compensation will be collected in Colombia, and keeping the individual in an unpaid leave, you stop paying Social Security in Argentina. You can terminate the labor relationship in Argentina while the individual is in assignment and pay Social Security in Colombia. And what is most important is that you can find other mechanisms to grant the individual the same level of pension at retirement. And such mechanisms are cheaper than paying 27% of the gross compensation. So it is important to understand that perhaps a policy that works pretty well for some countries perhaps will not work in the same way when you are talking regarding Latin America. I will provide another example, and in this case I will talk a little bit regarding Brazil, because you know that Brazil is quite different of the rest of the world. No? We think that in Brazil everything is green and yellow, but let me tell you that in Brazil legislation is always gray. We are black, no? You can see. Okay, so if you work in Brazil, what is interesting to know that Brazil will tax on income tax all the payments made by a Brazilian entity. It doesn't matter that the individual is working in Brazil or in another country. So, in the same example, suppose that there is a secondment from Brazil to the United States. The individual remains in the Brazilian payroll. The compensation is paid in Brazil, and allowances are paid in the United States. What it happened in this case is that Brazil will make a withholding on the compensation. It doesn't matter if the individual remains being tax resident or not in Brazil. The only change will be the rate, but it will be 27.5 instead of 25. Brazil will tax because Brazil will consider that it is Brazilian source, because the one who pays the compensation is Brazil. And what happened is that in the United States, the criteria is quite different. United States will tax 100% of the compensation because the service is carried out in the United States. 100% of the compensation will be considered U.S. source income. What it means that the income paid in Brazil cannot be credited against the American income tax, and this will generate double taxation. This is an important issue. If we use the same example, but on the contrary, suppose that you have an American people working in Brazil.
Well, let me go back. So how does a Brazilian company get around that? They want to have operations in the U.S.
Okay.
In Miami. How do the Brazilian companies operating here get around that?
Okay, well, it's quite difficult from Brazilian entities to terminate the labor relationship or to suspend the labor relationship because, well, my colleague will explain a bit better than me, but individuals can claim labor rights because if you suspend or terminate your labor relationship, the company will stop paying Social Security and will stop paying the FICHITS, the Fondo de Garantía por Tiempo de Servicio. And in this case, there could be labor claims. What I have seen in practice is that individuals remain in the payroll, the taxable base will be the same for Social Security and also for Social Security, but the compensation is paid outside Brazil. And this is the way in which they stop making withholding. Our suggestion is that, if possible, the compensation be paid in the place where services are rendered instead of Brazil. And let me tell you that I have the same example, but what happens if an American individual moves to Brazil and continue collecting the money in the home country payroll and allowances are paid in Brazil? What happened in this case is that the American entity is not going to bear the cost of such compensation, so after paying it, perhaps they will issue an invoice charging the cost to the Brazilian entity. What it is important to know is that Brazil makes a withholding anytime that makes a payment abroad. The withholding reaches 40%, and it will be an extra cost for the American entity, or an extra cost of the assignment, because assignment should be seen on a global basis, not only each location. You will have to have the four legs of the table anytime that you make planning. So in this case, you will have an additional extra cost. What we suggest is that in any case that it is possible, compensation be paid in the place where services are rendered.
And most companies do that, I presume.
Yeah.
Yeah. I'm going to presume this is one of those areas where the questions will be a little bit harder to get to because this is complicated stuff, and you're probably just helping people. But since we're talking about Brazil, Brazil's, as most of us know, their economy is slowing down a little bit. Everybody thought it was going to slow down after the soccer and the Olympics, but it's slowing down ahead of that. And what that means, from a legal point of view, is you end up with issues, right?
Yeah, what is happening now in Brazil is that the companies that are doing business there are having a strong real, so the currency is appreciating. The economy is slowing down. Social issues are arising. You saw all the riots before the Confederation Cup. and it's planning to happen as well in the World Cup and the Olympics, and the government is preparing to prevent that. So what is happening is that now the authorities and administrative authorities and judicial authorities are more pro-employee than before. In other words, before an employee in Brazil can sue you once, twice, 3 times, 4 times. There are, some people say that it's no statute of limitation that applies in Brazil. Some courts says yes, some courts says no. Signing a settlement agreement and enforce that settlement agreement in Brazil is impossible. You can sign the settlement, but even though that, the employee can claim that he was not aware of his actual rights, and therefore he can sue you again. So what is happening right now is an enormous amount of litigation is going on in Brazil, and companies are getting crazy because the judicial system, labor judicial system, is very, very old. It's back in 1960s. And the law, the labor law was enacted by a dictator, basically to say that he was not a dictator. And therefore the law is not current with the current situation of the world. So just to give you an example, overtime, the employees can claim overtime, and the company has no way to prove otherwise because they don't have this old system of the card signed by the employee and return it to the place of the clock. Remember the cars with the clock and the signature in the cars? That's not around anymore. And the only way to prove under the Brazilian law that the employee didn't provide overtime is by having those cards. So imagine a company with 10,000 pure companies trying to do that. Right? There's no way you can do it. So companies are now realizing that having a lot of trials, a lot of litigation. They don't even know how many cases they have. I've been in this year I've been almost the whole year in Brazil working in a project with a client that thought he had 20,000 cases. So they hired us to audit the 20,000 cases, and so we thought, wow, that's a lot of cases. So when we started reviewing case by case, comarca by comarca, jurisdiction, we found that the company in reality has 80,000 cases. So the company didn't know about 60,000 cases. And those cases are around for a long time. So, and they have judicial deposits made, the company didn't know about. So now the company has a huge, enormous liability it didn't realize. So now they're looking in a way how to reserve, how to make the reserves, proper reserves for that liability. And now the job of the project is next year review every single of the 60,000 cases and tell the client what's going on there. And if you check one case in Brazil, there is no way to know what is going on until the end. It's like the Venezuela soap operas. Basically at the end of the 100 pages, you realize, wow, this is what this guy is claiming. So it's not at the beginning. It's not like a executive summary for this. You have to read the whole thing, and then at the end, you realize, wow, that was what this guy is claiming. So in other words, if you have a company already established in Brazil, make sure you review yourself, meaning make sure you really know how many issues you have, how many claims, either judicial or administrative. And if you don't know, get those numbers right, because they are going to increase for sure. But the thing is, Brazil is going, the economy is going down, and social issues are going to rise. And maybe next year it's going to be even worse. So if you have a company there, review yourself. If you are planning to open a business in Brazil, which is great because it's a great company to do business, you can make a lot of money. You have to do it right and then plan well in advance how you want to do it. You want to hire an expert. Talk to my queen here, queen and king. Talk to the expert and see how you want to transfer the employees to Brazil. There are not many employees being transferred from Brazil abroad because it's almost impossible to deal with the transfer. It's impossible.
Yeah.
Last time I did this
How many do you transfer employees out of Brazil? You do. And
to terminate him or her before?
Yeah, we have to completely terminate them in order
That's the only, that's the only.
Yeah, a lot of discussion with the employee beforehand to have them understand the impact to them before they.
I was going to say that the only way to do it safely is just terminate the employment relationship, start fresh in the new country, but then you have to talk. I mean,
we
the
have
guy.
we have to pay them out. We
Yeah.
have to tell them the tax implications. You know, if you go back and you understand, you just have to. You just withdrew your whole Social Security, your
You have GTS.
FGTS, you know, everything, and so it's like they start all over from zero.
And there's no understanding in the Brazilian government that this is an obstacle to the growth of their country and the global worldliness of their people.
Like in other countries, I mean,
Maybe that's a dumb question. But
it's like any other country, like Colombia, which is now one of the best for investment. It has a provision in the commerce, in the mercantile code, commerce code, that obligates to pay a percentage of the business if you have an agent on the ground or you have an independent contractor on the ground. That provision was part of the negotiation with the U.S. and the free trade agreement. The U.S. made two conditions, asked the government of Colombia for two conditions in order to sign. One, increase and promote unions in Colombia. That was one of the requests from the U.S. government. And two, to get rid of that, because there is no way to send an independent contractor or an agent to Colombia, because at the end, if you want to terminate, you have to pay a percentage that is an equivalent to the amount this guy promote or got in that specific country. That's crazy. That part is crazy. The Colombian government knows that. They don't want to change it. Why? There are a lot of agents around there lobbying for it not to happen. It's the same thing in Brazil. So the Brazilian government knows this, and these people that you are going to terminate and transfer to another country, everything is going to be great. It's like marriage. Everything is great until it's not. So once, I'm not saying yours, but in our case, the guy is going to come back to Brazil and say, wow, I didn't know this. And the Brazilian court is going to say, yeah, you tricked that guy. The guy is a PhD in mathematics. I don't know. You tricked that guy. He didn't know what was going on. Therefore, he's protected, and whatever you did is not valid, and therefore the law applies, and you are owing him FGTS and so on and so forth. So it's not, you are not, I always say in Latin America that you never win. Employers never win. It's like Toy Story and Buzz Lightyear. You just fly with style. You know, it's like a falling with style. It's like I'm falling, but nicely. It's like that in Latin America. You have to do everything you can to prevent liability, but the laws are drafted to protect employees.
Ken?
yes.
I mean, for the companies here, I think most companies see the experience, international experience that are critical in order to grow your talent. And given the relative importance of Brazil, like in Latin America, I would imagine that you wouldn't move talent out of Brazil because of the difficulties that you face. And so I was interested, listening. If someone is not moving talent out of Brazil because of the difficulties, or you deal with what you have to deal, either you take the risk or...
In some cases, you assume the extra cost.
Yeah.
We have seen that companies assume the extra cost. The problem is what the extra cost is in the ears of the CFO. Because at that time they say, hey, we are wasting lots of money. It's incredible. Yeah. And another thing that I would like to add is that tax authorities in Brazil has their own interpretation of the rules. And perhaps, no, it's right. Perhaps there are countries that have signed tax treaties with Brazil, but at the end of the day, tax authority recognizes the domestic laws over the tax treaties. So we said, well, but the tax treaties has this provision, so withholding would not be applicable. And they say, no, if I pay, I will withhold. And we say, well, but the treaty, my interpretation is that I have to withhold. So it's very complicated, and my recommendation is that anytime that you plan an assignment where Brazil is part of the picture, you have to calculate the figures, because after that you will decide what approach you will follow. You can be conservative, but perhaps the cost of the assignment will double in size. another approach. The approach, as you previously mentioned, to terminate the employment relationship when the individual is in Brazil, but the issue here is the labor consequence that perhaps this decision could.
When I deal with transference from Brazil or to Brazil, I always keep that memo with me. So I really keep the memo. I send the client saying these are the risks, because I know after 5 years or 3 years or 2 years when the assignment finished, there's going to be an issue. So I keep the memo just to say, I told you, it's a business decision. I told you this is going to happen because there is no way to solve it. The best option is to terminate, but that doesn't mean that you are out of the hook. Because the authority in Brazil would say, you terminate this guy. He couldn't say no. He was under pressure. So he was under duress. So his new agreement is not valid. It's null and void.
Have you repatriated, or I'm not sure that's the word, have you taken people back into Brazil after having them come out of Brazil?
No, the way that we've explained it to the individuals that we brought from Brazil to the United States, we tell them the opportunity is you're coming here with no expectation that you're going back. Your career then is moving to the United States, and you're going to work in the United States and build your career in the United States if you're interested. And then we have lawyers in the United States that are speaking to lawyers in our Brazil operations, and the document is probably 25, 30 pages thick that this individual goes through. We sit with, and we talk, and we answer questions, and they sign before they take the assignment in the United States. It's expensive. It's an expensive endeavor. And again, even though you have that 30-page legal document signed and stamped by collective bargaining unions and everybody and their son and their mother and their brother, we know we're still at risk. They've got, X amount of years to go back and still claim that, they thought maybe, and you're right, employment law will protect them very, very strongly in Brazil.
So do all of you pay some attention to cross-border transfers when you're making it in your company? Who's from what country to what country, and the implications? Are there any country? Let's say you have a Chilean airline that's going to merge with Brazilian airline.
We moved from and to Brazil, but my question is more about, you mentioned that the recommendation was to pay the employee in the country where the services were rendered. But now we have situations in Venezuela and Argentina, especially, where it's not attractive for executives to be transferred just for the reason that they would not be able to take their money out of their country. So of course their request is, okay, I moved, the opportunity is good, but I need my salary to continue to be paid in my home country. And that of course goes against the recommendation, and it's an extra cost definitely for the company.
Exactly.
So what do you recommend?
No, because in this case, unless the Argentine entity, for example, has a bank account outside Argentina with enough funds hoarded in order to pay the compensation, and in this case, the Argentine entity will be bearing the cost, there is no alternative. I understand that nobody will come to Argentina under this scenario, and what most of the companies are doing is what you mentioned. They continue collecting their compensation in the home location. But the issue here is that the home country is not going to issue an invoice to Argentina, for example, because any time that you pay on behalf of another entity, from our central bank perspective, it is a financial debt. And according to our regulations, any time that an Argentine entity has a financial debt, it is required to enter the money to the country. But it is crazy because in this case, the money is not for the Argentine entity, it goes to the bank account of the individual. But if you do not comply with the requirement to enter the money to Argentina, you have an exchange control infringement, and the penalties are so high. There are up to 10 times the amount involved. So what is happening in practice is that the home country continues paying the salary, and no cost is charged to the Argentine entity. And this situation has another consequence, and it is that in the home country this expense is not going to be deductible from the corporate perspective, so it will increase the cost of the assignment. Yeah.
Do you give a loan? I mean, the foreign company entity gives a loan to
No,
the
because if you provide a loan, the money should enter to the country.
The same in Argentina.
Yeah.
Okay. In
They
Venezuela,
just can't get the money out.
Venezuela is not like that. You can. Go.
And what if the employee, if you use a company, you can prove that the employee continues, I mean, it will continue to be with a contract in the home country.
Yeah.
And what if the responsibility includes responsibilities in the home country and in Argentina or Venezuela? So basically, it's performing a position that.
No, in fact, for example, in Argentina, there is no problem. And in fact, most of the American companies have this kind of contract where individuals remain in their home payroll. It does not mean that from the Argentine perspective, the taxable base will be the allowances paid in Argentina. From the Argentine perspective, all the compensation that is compensating the activity carried out in Argentina should be subject to income tax and also social security.
For both the company and the employee.
What do you mean?
Yeah, the company has to pay payroll taxes.
Yes, payroll taxes. Yes, from the company. Yes, you will have a salary slip with 100% of the compensation. You calculate social security, income tax, and you will include a line saying that part of the income was collected abroad, so the net will be equivalent to the amount that you pay in Argentina. Of course, on the gross compensation, so, individual will be withheld, and the company will pay the 27% social security rate. And you have exemptions if you send to Argentina professionals that will be in Argentina for less than 2 years. You can submit some documents before the social security and authorities, and perhaps you can grant an exemption for social security. And in this case, if the exemption is granted, it will apply to the employee and also to the employer.
Thank you.
So what about other countries? So Brazil is tough, Argentina is tough. You want to touch on Venezuela a little bit more?
And Mexico.
Speaking of tough,
How about Mexico?
Yeah.
Mexico.
They just changed the law.
They did.
Any thoughts on Mexico?
Yeah, with regard to the labor law in Mexico, it was reformed last year. The reform specifically touches areas of very concern of the companies. The first area of concern is profit sharing and how profit sharing should be calculated and paid. Before, the law allowed companies to have two different entities, an operating entity and the entity that was making the money. And therefore, the operating entity that has all the cost was the one that was paying the 10% profit sharing. So now it is a huge debate in Mexico, and perhaps you already have a legal opinion or a tax opinion, whether you have to consolidate your two entities and pay the 10% of profit sharing from the real business, or you can continue doing what we were doing before. As far as we know, there are not final decisions from the Supreme Court of Mexico, there are not court rulings, so our recommendation is just wait and see. Don't go crazy and start paying the 10%, because once you do it, then, as I said before, you just have one chance. If you make it wrong, that's it. So what we are recommending our clients is just wait, see what is going on. You don't want to be the first one to pay. You don't want to be the first one to get fined. So let's look at the situation and before jumping in. The reason why we're recommending this to our clients is that we don't believe that, based on the common idea of bringing more investors to Mexico, this change will kill the investment right away. So we think that something is going to happen, either a ruling from the Supreme Court or a decree that regulates that specific area of the law and clarifies it. Then the second major issue is how to interpret the definition of outsourcing in Mexico, whether outsourcing is valid or not, whether you can outsource your core business or not, what core business means. But Mexicans are very intelligent. So what they did was drafted the law without any meaning whatsoever. So the law has no meaning. A specific article is no way to interpret. So you can say yes, no, more or less, I don't know, whatever. That's what the law says. So basically, what they did was, and you know, these labor laws are, especially in Mexico, where unions have a lot of political power, is a negotiation. It's just, okay, I give you this, you give me that, you put this article here, you get rid of that one. And that was one of the main issues at the end. It was one of the last articles to be approved was the outsourcing. So what I did was, okay, I cannot give you that, you cannot give me this, so let's draft it in a way nobody understands it, so you can tell your people that you got what you want, and I can tell my people I got what I want. So in practice, it's outsourcing right now in Mexico is common business, is meaning is normal, is you can do what you were doing before. However, try to limit a little bit the activities you perform, like are really part of your core business. Don't start having them now new, fresh, outsource, because that's likely to change. Why? Now with the reform, the tax code reform, and the oil and gas opening, Pemex is already entering into an agreement with Mobil. So Mobil is basically running Pemex. And then everybody's waiting for Pemex to open the possibility to provide to third-party providers, even partners, to be on the ground taking oil and selling oil. So outsourcing is probably one of the cards that are going to trade. So meaning the union are going to let Pemex do that in exchange of the outsourcing not to be to third parties. So everything has to be in the Pemex, the oil and gas company owned by Mexico. There are minor things about the changes of the law that are not relevant. Really, these are the two main things.
One, I don't know if in this room there are companies that send Chilean people outside Chile. And to which countries?
All over, Brazil, Mexico, the US, Argentina, Colombia, Ecuador, Peru.
Because you know that there was something new in 2013, and it was that the tax treaty signed between Chile and Argentina is no longer in force. And there are a huge extra cost if the individual remain in the Chilean payroll. I don't know if it is the case because Chile has no specific provisions regarding in which moment individuals lose their resident condition. You know that in other countries, when you stay in another location for more than 183 days, you lose your resident condition, but it is not the case of Chile. And tax authority understood that if you remain having a contract in Chile, you remain being a tax resident in Chile. What did happen is that the domestic legislation do not allow to compute tax credits if there is no tax treaty in place. Suppose in the example that you have an assignee from Chile working in Argentina, the individual remain in the Chilean payroll and remain being tax resident in Chile. Once the treaty was in force, the provisions of the treaty states that the power to tax will be of the country in which the activity is carried out. In this case, Argentina will tax the income, and Chile is not going to tax anything. The issue that now, if the individual remain being tax resident in Chile, they will calculate the income tax in Chile, and the income tax paid in Argentina is not going to be computed as a tax credit because there is no longer a tax treaty in force. And considering the tax rates, you know that income tax in Argentina, the highest rate is 35%, 40% is in Chile, and at the end of the day, the effective could be 35%. But if you have to make gross up to do not increase the cost for the assignee, because generally they are equalized, it means that the cost of the assignment will be 53.84% higher.
Wow.
Because of the effect of the income tax. So there is important thing to take into account in those cases.
Just to share with the group, as Chile is one of the countries that we incorporate a lot of executives, we don't leave executives in the local payroll in Chile.
Okay.
So one of the advantages that Chile has is that the people can do voluntary payments to retirement, to AFP. AFP is happening to health and to retirement, AFP and ISAPRE. So we do help them with the administrative task of doing the payments if they need it, but the employees do it themselves. So they do not continue in the payroll, so they are not tax residents.
You don't have the problem.
And we don't have the problem, and they continue to do to contribute to the retirement. Both retirement and insurance are very important because insurance in Chile contemplates pre-existing conditions. So it's very important that they don't lose the seniority with insurance companies, and also the retirement, so they can do it voluntarily.
Because we pay that little amount extra.
Exactly, we pay that little amount extra on their salary as a net amount, so they do it themselves.
And where are the headquarters of your company?
Chile and Brazil.
Okay, that is why you do not have a policy that states that individuals should remain in the home country payroll.
Exactly.
Yeah.
And actually, our practices mostly do not. They have to be paid where the services are rendered. We do have issues with the U.S. citizens that they don't really want to be fully compensated in the countries that they are being assigned. And now with individuals going to Argentina and Venezuela, basically for the current situation.
Okay, that was why I started saying that we have policies that they are so rigid in this sense, and you don't have the chance to do things as you have mentioned, to remove individuals from the payroll. At the end of the day, you bear a lot of extra cost. And you started this session saying how to avoid millions of dollars. Believe me that when you make the calculations of Social Security, you will find out that in so many cases you exceed the $1 million per year. We have plenty of cases in which they are changing their policies. For example, in the case of Argentina, with 27% Social Security tax rate, that they are changing the approach for Argentine people going outside just to avoid millions of dollars per year. Believe me.
So I'm not exaggerating.
You have to make the calculation because it's quite difficult to make changes. It's quite difficult to make changes when you are not located in the headquarters. But anytime that you show the figures, is the moment in which perhaps the headquarters take into considerations that perhaps there is another way to make deals that they are less expensive. Yeah.
Other countries? Wage in another country? Venezuela, you want to touch Venezuela?
I just want to mention about Venezuela, since Venezuela has many terrible things. I'm from Venezuela. So there's one good thing about your issue. Venezuela has no problem whatsoever with regard to selling the currency to central bank and so on. So you can pay from abroad your people working locally, and your people can be locally in the payroll as far as you have either you pay yourself the contribution for the payroll taxes, or you have a small phantom salary or a small salary that can pay for those payrolls. So that's the good part about the system in Venezuela. And if you compare the labor laws, even the new one that was enacted last year in Venezuela, labor laws in the countries, the labor law in Venezuela is not that bad. The problem is the guy that is interpreting. I mean, the person that is in charge of the labor board in a specific area where you have your plant. The guy thinks that he's, the Che Guevara too, or Fidel Castro young. So he feels like you are the enemy and he has to destroy you. But it's not a labor law. It's basically the system, the way is now in place that is taking. He's making those issues to complex. But in case of a payment in dollars, there is no issue whatsoever in Venezuela. In fact, it's very favorable comparing with other countries.
Yeah, and one of the topics, we sort of run out of time. One of the topics we can talk about that we can talk about over lunch or in the break or something if you have interest in this is really the issue of currency fluctuations. So we'll have that as an impact as well. So there's all sorts of great topics here. But we'll take a brief break now. And you can catch up on your emails.
Excuse me.
Oh,
Just
we're
one
not taking a
little
break right
thing,
now.
because I can see your faces when we talk a little bit regarding Latin America, and I would like to show you. I brought something
Do they
with
look
me.
scared?
No, no. Yes, I said how it could happen. But as he previously mentioned, you have rules, perhaps they are not clear, and I will let you know why they are not clear. And I wrote something for you. This is the Internal Revenue Code in the United States. This is our income tax law in Argentina. And the same happens with Mexico, with Chile, with Brazil. We have less than 200 articles in our legislation. So, well, anytime that we have a call and say, hey, but are you right? What are you telling to me? I say, well, no, there are no provisions. And the reason why is because the different side of the provision. Here you have the provisions in the United States, and here are the provisions in the Latin American countries. So perhaps it provides you a better understanding of why anytime that you call the Latin American region, you cannot understand why everyone say, well, I don't know, it could be this way or it could be this other way, and it's not clear. We need to analyze some precedents, some jurisprudence, and this is the reason why. I think that it's better to show.
I'm not so sure it's that clear in the U.S. anyway. No matter how big. And that's just A through C, I think. That's not the whole book. That's just yeah. Okay, we'll take a brief break. I think it was a great discussion. Thank you for your